All right, it's right at 1 o'clock. We need to go ahead and get started so that we can give Jim an opportunity to say all he needs to say. I just want to say this is a collaborative effort between the Middle Georgia Parent Mentor Partnership, and we appreciate everybody being here today. And I also, just for housekeeping, want to say that we will have a question and answer session at the end. And if you think of a question, please type it out in the comment box, and then we will answer it at the end. And I did just get I will be muting everybody else's mics except for Jim's. Or if you could go ahead and do that for me. Okay. Looks like everybody's muted. All right, Jim. I'll introduce you. This is Jim McCarten. He's an attorney, and he is going to be speaking on guardianship today and what to do after your special needs child turns 18. And Jim, you can introduce yourself a little bit further so we can kind of get to know you.
Well, thank you very much, Jennifer. And I think Lori knows me better than she wants to know me. So my name is Jim McCarten. Like many of you, I'm a parent. I have a daughter who is now 26 years old and is on the spectrum. And as a lawyer, I've gotten to see both sides now of the issues involved in guardianship and conservatorship and on into the special needs planning that we all worry about and need to take care of for our families, but especially our children. I appreciate you all asking me to spend some time with you today. It is always important to me to spend time with our community and add value wherever I possibly can. I am a lawyer, as I mentioned. I did not get into special needs planning until my wife and I learned that Catherine had autism. I started out life as a tax nerd. And if you were to ask Catherine to introduce me, which she has done on a number of occasions, she will tell you, this is my dad, the tax nerd. So you get what you pay for, ladies and gentlemen. And I am old enough that instead of fighting that label, I now try to embrace it. So when we start talking with what we're trying to cover today, I am going to go through in a very specific fashion, and then we'll come back and talk about and go through questions. And as I go through, I will also add some comments related to our personal experience with Catherine. Now, when you start sort of the concept of what about guardianship, what about conservatorship, you really have to understand sort of the basics of the law, because guardianship and conservatorship require that you go to court, okay? So prior to age 18, as a parent, you have the right to control decisions for your child. And actually, it's the right to age of majority, which in Georgia is 18. In point number 2 here, it's really a restatement of that. I also mentioned that there's a concept of emancipation. That is not going to apply for most of our children. Emancipation is a process where a child who is not yet 18 can be freed of parental control. It takes a court decision. It is often a very difficult court hearing for both the parents and the child, and so you know that that's out there. So what happens when a child with a disability turns 18? Well, let's talk about guardianships first. And Jennifer, if you'll change, yeah, there we go. Thank you very much. So at 18, the law presumes that your child is able to make decisions for him or herself. So as a practical matter, at least with regard to everybody else in the world, your child can make a knowledgeable and responsible decision. Now, that may not actually be true. And that's what guardianship and conservatorship are for. So guardians are those people who are appointed by the court to assist the ward. And the ward is the term that the court uses to indicate the person for whom a guardianship is sought. Now, we're going to focus on guardianship for those of our community who are turning 18 or have recently turned 18. But guardianship is also a big factor for us as we age, as our parents age, and we often see guardianship sought for parents who are unable to make their own decisions. So the court uses the term ward. And when you look at, let's go back to that last slide if we can, Jennifer, before we get out of here. And so it's the making and or communicating significant responsible decisions that is the touchstone of guardianship. So the court looks to see whether your child can make or communicate and communicate. So if you can make them and communicate them, you're good. If you can make them, but you can't communicate them, a guardianship and conservatorship may be in order. As a general rule, the way to think about a guardianship is that the guardian is in charge of the ward's person. So we deal with guardianship as being for the person, and then conservatorships for the property of the individual. And that leads us into the next slide. So a conservator, when you talk about what the court looks to, is appointed for someone who lacks sufficient capacity to make or communicate significant responsible decisions concerning the management of his or her property. And it's also important to understand that the conservatorships are designed by the courts. The orders are supposed to take into account the encouragement and the development of maximum self-reliance and independence, so that we are using less restrictive alternatives to the extent they are available or appropriate. And that's become a very important aspect of guardianship and conservatorship law over the last 5 to 10 years, that the courts really are being much more attentive to the questions of, are there certain aspects of a child's life or a young adult's life that he or she can make decisions about? And if that is the case, the court will often carve those out of the types of decisions which the guardian or conservator will make. So let's get into then some of the specifics with regard to guardianships and conservatorships. And then, as the next slide makes clear, These are judicial tools. In other words, you are not a guardian and you are not a conservator unless or until a court has appointed you as a guardian or conservator. And because of this movement toward the less restrictive alternatives, the court may not remove all decision making. Now, I saw a question pop up, and that's a good point to address it. You have to ask to be named a guardian and a conservator. If you only ask to be named a guardian, you do not have rights of control over property. So you have to ask to be both. Guardians are not automatically conservators, and conservators are not automatically guardians. Now, the one thing that many people get confused about is this right to marry. Oftentimes, we see people who have been appointed as a conservator, but not a guardian, believe that they have the right to control whether a ward marries or not. And the answer to that is not part of a conservator's governance. You don't control that aspect of a ward's life. On the other hand, if you are a guardian, because you are asked to support the individual with regard to the person, you do have control over the right to marry. So let's then look at conservatorships, which is the next slide. And what I've done here is given you a list. Jennifer, I think we're into the next slide if you can. There we go. So here's a list that is included in the Georgia law, the Georgia statutes, about what a conservator does. And it's a very short list, and that is a conservator then controls the right to contract. And this is, in my view, perhaps the most important aspect of a conservatorship. Catherine is relatively high functioning. She gets on the computer, she'll play these interactive computer games. She understands about trying to buy some of the extras that come through these computer games. She understands about trying to buy a car or buy other expensive types of computer equipment that will make her gaming that much better. She has enough intelligence and innate ability to figure out how to game the system, and will and has tried to buy additional equipment for her computer. When we were serving as her power of attorney, we could not automatically get between her and some commercial business. And that is why the court order becomes so important. So if you don't want your child having the ability to go out and borrow money, you want to go ahead and have a conservatorship, because the conservatorship is a court order. It is filed in the court records, which are public, and the presumption is that anybody who deals with your child should be aware and know that there is a conservatorship, and your child does not have the legal authority to contract. And contract includes buying and selling and disposing of property. Other commercial transactions, They can't really do their own estate planning, and nor can they bring or defend a lawsuit. So that's all of what is included in a conservatorship. The courts these days get much more detailed. So there's really a list of about 20 kinds of rights that the courts deal with in conservatorships and guardianships. So here we have the list from the law with regard to guardianship and what is controlled. Marriage, making of contracts, but that is not the same as necessarily going out and being able to obtain credit. So you have to understand that the law makes distinctions between the types of commercial transactions that your child might undertake that you and I would not make. And so it's important that you always approach this as being both the guardian and the conservator. Where I believe the guardianship gets really important is this consent to medical treatment and the choice of where to live. Those are two very important aspects of Catherine's life that we would be very concerned if she was the only one making those decisions. We also have the right to revoke a revocable trust and or bring or defend a lawsuit. So there's a little bit of overlap between a conservatorship and a guardianship. So the thing to remember is that while there is overlap, the courts will require a conservatorship if you are dealing with your child's money or property in any form or fashion. There is some distinction there, though, because with regard to the supplemental security income, SSI, that many of our children qualify for, the Social Security Administration will require that instead of the money being paid to the individual, that it be paid to someone who is named to support that individual. And so if you are receiving those funds on behalf of your child, and the term that Social Security uses is you are a representative payee of your child. Federal law controls the fact that you have to use that money for your child's benefit. So the Georgia courts don't view that they have to oversee your use of SSI. On the other hand, if there are other resources, your child has an inheritance from a grandparent, your child has received other resources from a lawsuit, then the court is going to require that you be a conservator. Now, when you start thinking about conservatorships, it's important to also think about the fact that none of us have any clue when the good Lord is going to call us home. We have to think in terms of the fact that we may not live out the year. We may not live out the month. And if that happens, who is going to step in and take care of our child for us? Who is going to be the next conservator? Who is going to be the next guardian? And there is a process in Georgia by which you can name the next conservator and guardian, and that's called a standby conservator or guardian. And that's important because all that has to happen to transfer the powers that you have for your child to that other person is for them to file a quick statement in the courts with regard to the fact that you are no longer able to handle that position. That means you save a lot of money with regard to attorney's fees, and the amount of paperwork that has to be filed is significantly less. So I always encourage clients that I am working with to think in terms of who would be next right now, and let's make sure that we have listed them as a standby conservator when we go to court. Now, for those of you who are married, the question is going to be, are you and your spouse, whether it's a husband or whether it's a wife, are you going to be co-conservators and co-guardians? And that is perfectly fine. There's nothing wrong with that, and that means one of you can handle most of the business that needs to be handled. As a co-conservator, you don't have to have both individuals before. For example, if your child has to go to the hospital, you've gone on a trip, your child is over 18, you're going to a new hospital because there's been an accident. That new hospital is going to want to know who has the ability to control the choice of medical treatment. And so you have to have one or the other, and you want to have a copy of that court order. So who gets to serve? Well, for the most part, it's going to be the individuals who are seeking to be named as guardian. For children who are in the throes of going from being a minor to being an adult, it is often going to be the parent. When we have our parents who are no longer able to care for themselves, it is the child who is seeking to be named the guardian or conservator. And if there are 4 or 5 children, the children need to decide who is going to be in charge first. Otherwise, it is going to be a very expensive proceeding because the court is going to require anyone who wants to be the conservator to present a case as to why they should be the conservator rather than one of the other brothers or sisters. If a parent is not able to serve, the parent may nominate a person, and that individual will be given preference over others, even others as to siblings. So we have 3 adult daughters, Catherine being the youngest, and we have now named our 2 oldest as our standbys. But before they were old enough to serve, back when they were still in college, so they were over 21, but we didn't believe they really should be straddled with the responsibility of taking care of their sister. We used my sister and my wife's brother as our standbys. So we nominated who was going to serve afterward, and that nomination would have overridden any effort by her sisters to become guardians if Diane and I could not serve. So let's move on then to the next slide. And that gets into the question of, do you want to use a guardianship or a conservatorship. And I will tell you that Diane and I struggled very long and very much in making the decision on whether to seek to be Catherine's guardians and conservators. We were concerned while Catherine was 18 and still working on her maturity and struggling to be as self-sufficient as she could, that having a court tell her she was no longer responsible for her own actions, that she would take that way too literally. And thus, she would just decide that she didn't have to be responsible for herself. And we didn't want that to occur. So we did not seek guardianship or conservatorship initially. It wasn't until Catherine was about 23 that we got to a point where we decided we really needed to go ahead and seek a guardianship and conservatorship through the court process, because we were afraid that Catherine might decide that she was done with us helping her and supporting her, and might decide to tell somebody, whether it be a doctor or whether it be a third party involved in housing decisions, that she didn't want us involved in the decision-making process anymore. And the way that, and so we finally decided to seek a guardianship and conservatorship. So what do you do if you don't? If you decide you don't want to use or want to see what is going to happen with your child during the interim, what is going to happen over the next couple of years? Well, as indicated in the next slide, you would use a couple of documents that we use otherwise for individuals, and that's a durable power of attorney and a healthcare directive. So, excuse me, if something happens to me, I'm in a car accident, I'm taken to the hospital, and I can't tell the doctor what to do, what kind of medical treatment I want. You know, if there's a choice between different types of surgeries that mean I will have better use of my arm or lesser use of my arm, and if I'm not able to make that decision, my healthcare directive says, let my wife make that decision. If my wife is not available, it says, let my middle daughter, who has some medical training, make that decision. If she's not available, then it's my oldest daughter. So we have already set up a structure. We used powers of attorney for Catherine for many different years. There are problems, though, that can arise if you are using something less than a court order. And the first of those is that the third party, and most often this is a medical provider, might question whether your child ever had the capacity to contract, and thus the power of attorney or the healthcare directive is by its terms invalid, and they won't follow your direction. And I have seen that happen with other people who have had problems, especially when they have moved into new areas. You know, you move from Columbus to Albany, you may or may not get the same response in Albany when you're new that you did when you were in Columbus and had been in Columbus, so we're using the same medical providers. You know, if they know your child and know you, they're much more likely to honor the power of attorney. If they don't know you, or it's a new provider, there is a significant chance that they may question its validity. The other aspect of using this non-court procedure is that your child may decide that he or she does not want to continue to allow you the power to control what is happening. And under state law, while I can draft lots of things that say they can't revoke it without doing something in writing, the fact is that it is probably sufficient for your child to tell this other person, whoever that is that you're dealing with, that they are revoking the power they've given to you previously. So you have to think about that. And Catherine at times can be very, very headstrong and not necessarily want to follow the guidance that her mother and I tried to provide. And so if that happens and she gets very stuck in the fact that she doesn't want to do something that we are trying to get her to attempt, then a power of attorney may not do what is necessary in order for us to accomplish that. Now, last but not least, because a power of attorney is most often not filed with the Register of Deeds and it's not a court order, it does not mean that I am going to be able to automatically undo a bad deal that Catherine may have signed up for. So, for example, Catherine drives. She can actually go out and she can be somewhere without her mother or I being with her. And in that case, if she took one of our cars and went to a car dealership and signed a contract to buy a used car, if we were not her court-appointed guardians, we could not automatically undo that contract, which would mean she might have to pay at least some amount to get out from underneath that contract. And that is not something you want to experience when your child is only receiving somewhere in the neighborhood of $500 to $700 of SSI if they are living with you. So it's important that you understand that you want to be able to ensure that your child is not going to go too far and make decisions that you will not be able to undo if your child does go down that road. So let's go to the next slide. One of the things that is really important here is what happens for your child if he or she is continuing in the school system past the age of 18. Not so much in Georgia, but as background, when Catherine, up until Catherine was 19, we lived in Tennessee. We lived in both Oak Ridge, Tennessee, and Nashville. And in Oak Ridge, which is a much smaller town, after she was 18, we had the school system tell us we could not participate in her IEPs because we did not have an education power of attorney, and we were not her guardian or her conservators. So understand that if you decide not to be a guardian or a conservator, besides a traditional financial power of attorney and a healthcare directive, which is effectively the equivalent of a healthcare power of attorney, you will need or want an education power of attorney. And those are very specialized, and there are not many lawyers who understand how to draft those. But you will need them often in dealing with the educational system. Now, you also want to make sure that whatever decisions you have made tie into your long-term plan for what is going to happen for your child with a disability. You know, again, the whole issue of special needs planning is that I cannot guarantee you that I will be here next year. I can't guarantee you that I will be here 3 weeks from today. And so if that happens, if something were to happen to her mother, if something were to happen to me, how have we decided that Catherine is going to be supported? You have both personal support that you have to deal with, and you have financial support decisions that you have to deal with. And if you don't take the time to make those decisions now, you are leaving those decisions in the hands of others. That can be in the hands of the state. It can be in the hands of the court, depending upon what size of a family and support system your child has. In taking the next step with planning, it is really important that you also have your personal plan outlined. So what is going to happen for you with regard to retirement, for example? Have you planned for retirement? Because as we all know, it's hard enough taking care of your child now. Are you going to be in a position of having to work until age 70 or 75 just to make sure that your finances are met? And then what does that mean for your adult child? So special needs planning across the lifespan is very important, and that means planning for you as well. You don't want to be spending all of your money now and then never be able to retire. So financial planning is extremely important when you have an individual with a disability who is part of your family. Now, one of the things that both Jennifer and Lori asked me to do is covered in this next slide. And here I've got for you a list of resources. Now, note at the bottom, we're talking about court costs. Anytime that somebody files an action in the court, they ask the court to do something for them, there is a charge, and those are called court costs. For conservatorships and guardianships, then you have a cost, and that cost for most of the courts is anywhere from $490 to $750. And it depends on jurisdiction. The city of Atlanta is a little bit more expensive than Fayette County. The Cobb County and Gwinnett County are more expensive than Fayette County. but Fayette County is more expensive than Coweta County. So you have to understand what that is. If you cannot afford those fees, the courts have programs for full or partial waiver of fees based upon ability to pay. You have to apply for that waiver, and applications are found at the office of the clerk of the court. Now, that deals with your out-of-pocket court costs. What's the other cost in going and seeking conservatorship or guardianship? Well, of course, it's the lawyer. And lawyers are not cheap. You know, lawyers for conservatorships can run anywhere from $1,000 to $2,500, depending on travel time and other factors that are involved in the representation. So if you need help, you can seek pro bono representation. Again, most pro bono representation is based on need. Do you have the ability to pay? Obviously, as a lawyer, I am always going to be treated as having the ability to pay. What about a mechanic down at the local auto shop who has 5 kids? Well, that family may not have much extra cash and may indeed qualify for free legal support. The resources that I've listed here are those resources who will represent you in court. Georgia Legal Services Program is by far the program that we see most often outside of Atlanta and outside of any of the metropolitan areas, so out in the rural communities. It's Georgia Legal Services. Middle Georgia Justice deals with the Macon area and some of the surrounding counties. They don't go terribly far, but you will want to look at their website to see if they will work in your jurisdiction, in your county, if you need pro bono support. Last but not least, many local bar associations. So, for example, the Fayette County Bar Association will provide referrals to lawyers who will handle these cases pro bono. A partial list of those bar associations can be found on the website of the Georgia Bar Association, and I've given you that link next to this. But if you know a lawyer, if they are not a probate lawyer or not somebody who deals with guardianship, you can ask them to put you in contact with the local bar to find out if anyone locally will handle any pro bono referrals. So, ladies and gentlemen, that brings us to the end of the pro bono discussion. And the rest of the slides deal with the overarching need of financial planning. So what I now refer to as special needs planning. I'm going to take a break here because we want to make sure that we get to questions. I've already used up quite a bit of our hour. Like every lawyer, I can talk. I can fill as much time as you give me, but I want to make sure that we've got time to answer any questions that any of you have raised. And I see that we've got a few, Jennifer. Do you want to go through those and read them out and I'll handle them, or do you want me to pull them up?
I can read them to you.
Okay.
Okay. So let's see. This is from Brittany. Is this done at one hearing with one application for both? Question mark.
And the answer to that is yes. For most probate matters, and I'm probably telling you more than you want to know, but for most probate matters, the Georgia courts rely on form pleadings. So even if I am representing somebody who is trying to probate their parents' will, I have to use the forms provided by the court. There are guardianship and conservatorship forms. It's about 25 pages, but they're not terribly difficult to look at and go through. But you do have to indicate to the court that you want to be both the guardian and the conservator in those pleadings, and the court will make that determination in the single hearing. Okay?
Okay. Angela, she was asking if I will send a copy of this recording. Yes, we will be sending out, we will make the copy of the recording available to whoever needs it. So yes, it will be available. The next question, do they have to sign something?
They being the child, I expect that question is focused on.
Yes.
The answer to that is no. What will happen is that the court...
Wait. Brittany says no, not the child, the standby.
Yes, oftentimes the standby will be asked to sign the page in which they are nominated to say that they will serve.
Okay.
And it's not very difficult. I mean, that signature does have to be notarized, but again, it's on the page for standby designation.
Okay. Let's see. When the child's parent is mentally and physically disabled and want control of the disabled child, how is that handled?
Read that again.
When the child's parent is mentally and physically disabled and want control of the disabled child, how is that handled?
Well, the question is going to be whether the parent who has disabilities, him or herself, is able to serve. Now, if they are competent, and that's the question that the court will look to, is competency, which really means, are you able to help your child with those decisions? The court will not be worried that you have a disability, except to the extent that the court will want to be able to ask questions of you at the hearing to ensure that the court is comfortable you can handle the responsibilities. But there is nothing in the paperwork that will prevent you from asking to be appointed. Now, you probably want to talk about the likelihood of appointment with whatever lawyer you're working with, so that you understand whether or not the local judge is likely to allow the parent to serve. We have situations where one judge in Fayette County may be a little more lenient and much more concerned about the family, whereas a judge in another jurisdiction may be very much by the book, and if competency is not allowed, is not present, they will not allow the parent to serve at all, period. So it's a balancing act, and you need to figure out how your local judge might handle that.
Okay, next question, do we need a lawyer for this? The
court will encourage you to have a lawyer. Now, most courts will at least quarterly or biannually, which is once every 6 months, have little workshops where they'll go through how to fill out the paperwork so that you can try to fill out the paperwork by yourself. You can, if the court allows, represent yourself. Now, the question is going to be at that point whether the court is comfortable that you are making the right arguments with regard to the needs of your child. And if the court is not comfortable that you are adequately explaining the need, the court, the probate judge, may suggest to you that they'll put things on hold until you get a lawyer to assist you.
Okay. Next question. Right now, we don't get Social Security benefits due to my income. How will getting guardianship affect any benefits for the adult child?
I suspect that what we've got is a minor. And so what you have for government benefit rules, under the age of 18, the income of the household is what is reviewed. Once the child becomes 18, that child is viewed as his or her own household, even though they may be living with the parent. So at age 18, they are going to qualify for SSDI, and from SSDI, they move into qualifying for Medicaid support. Now, the question for Social Security is whether your child is disabled for Social Security purposes, which is a unique definition. And it gets down to the question of whether or not your child can undertake substantial gainful employment and activities. And so there's a question of how you prove that. Social Security can, just like every court, be different based on who you're dealing with. So it depends on who the representative is that you are when you go to apply for SSI for your child, and you may need to talk to somebody else, some other support system, as to how to make sure that your child receives SSI and is granted SSI after the application. So it's two different types of rules. So SSI pre-18 means you look to the parent's income. Excuse me, post-18, the child stands on his or her own.
Okay, the next question is, when should we apply? And then there's another one. Is it a few months before the child reaches 18 years, and how long will it take?
Well, I would have told you last year about this time, really before COVID hit, that it was going to take 3 to 4 to 6 months. With COVID, things take much longer in the court system. So it can take up to 8 months or more for the court to get around to a hearing, because hearings are not happening very often. Mm-hmm. And the court will not grant conservatorship or guardianship without an actual hearing. So it is going to take longer these days. As to when to file, if you have the ability to file before your child turns 18, and I basically tell clients about a month before is when we ought to be filing, because that paperwork is going to take a while to go through the court system, and we want to have the guardianship and conservatorship in place as soon as possible. So probably get started with a lawyer or with filling out the paperwork somewhere around 2 to 3 months before your child turns 18.
Okay. We're back around. The mentally challenged parent isn't able to take care of the child. There is someone else over the child now.
Okay. So that I am going to make an assumption, and that is that that individual is or has been named the actual guardian of the child. Normally, when a parent cannot care for his or her child, either the state is going to take custody or the state is going to have a third party step in, usually family if at all possible, and care for the child. In that instant, usually the person who is handling the child, whether it be foster care or some other structure, will have legal authority through the child services, or already have been named a guardian. If they are already a guardian, you still have to file for permanent guardianship and conservatorship, just as if you were the parent. So you would actually file for that legal relationship to continue after age 18. Okay. I hope that answers that question adequately.
All right. Next question. Touch on how to handle this for divorced parents when one parent applies to be guardian.
Well, that's going to be one of those questions that, just like the divorce process itself, can the parents work together to ensure that they are doing what is best for the child? A lot of times they can, but equally often they cannot. And so if they cannot, oftentimes one parent will go ahead and file the application, file with the court, and basically the other parent then is notified by the court that the guardianship is being sought, and that non-custodial parent or the other parent has the opportunity to file and object to the guardianship or object to that one parent being the sole guardian. So it really is one of those questions that, if at all possible, I encourage divorced parents to try to agree as to how guardianship and conservatorship are going to be handled before you actually file. Sometimes that's just not possible.
Okay. What will happen to IEP?
So IEP, again, deals with the school systems. At age 18, if a child is still in the school system for whatever reason, whether it be because they're in their senior year or because they are going to remain in the school system because of the supports available, so up to age 21 or 22, the IEP controls what happens for them during the school day. A guardian, if indeed you have been named the guardian, has the ability after age 18 to control what the IEP looks like in conjunction with the school systems. So just as it was a negotiation prior to age 18, it's going to be a negotiation after 18. If you are not the guardian, but have an education IEP, and the school system is willing to let you use that IEP, that education power of attorney, it'll be the same negotiation. If you don't have either of them, you may be forced by the school system to go get named, or they will not include you in the process.
Okay. Let's see. This says for SSI benefits, question mark, how can we apply? Do we need an attorney?
You do not need an attorney. I would suggest to you it's important to talk with other parents who have been through the process.
Mhm.
The process is not an easy one, but it's not overly difficult either. What is going to be very important for Social Security is that you bring in whatever is important to prove your child is unable to undertake substantial and sustained gainful employment and or activity. So a lot of times your IEPs, a lot of times the school systems will have referred your child out for psychoeducational testing, and you will have copies of those reports. You're going to want to take copies of those when you go to Social Security. Now, they will oftentimes say that those are not binding on Social Security because it's a different standard, but they will use them in making the determination. And unless you've got somebody for Social Security, a representative there who is unreasonable, they will oftentimes use that paperwork.
Okay. Let's see. Stacy said, I was told to apply the month after they turn 18. And she is referring to SSI.
That is correct.
Yes.
And you apply with the Social Security Administration, the local Social Security office.
Uh-huh.
You can go online and find out where that is. It may not be in your local county. It may be one or two counties over.
This next one, my child just got approved for Katie Beckett Medicaid, and she will be 18 in September. Will Katie Beckett assist with getting my child approved for Social Security and Social Security Medicaid?
No. You will be responsible for going to Social Security and handling that yourself. Medicaid, especially in Georgia, does not assist in those activities.
Okay, well, those have been some great questions. If we don't have any more, Jim, how do you want to move forward with your slides, or?
Well, we're way past an hour,
Okay.
so if you all want to have another one of these in a month or two and really get into what is special needs planning, so what happens with a child if you become excuse me, incapacitated? How do you plan for what happens if you pass away to ensure your child continues to have access to government benefits? We can certainly do that.
Great. That sounds wonderful. We do have one more question. How does DBHDD services apply with a young adult?
DBHDD services really is the group that oversees the Medicaid waiver services. Mm-hmm. So I can use Catherine for an example. We got Catherine signed up for Social Security SSI income, supplemental security income, just right after she turned 18. And ladies and gentlemen, you apply when she turns 18 and it doesn't get approved until 3 months later, they will make back payments to the date of application. It doesn't start on approval. So what you do is you go ahead and you move forward with that. Somewhere between 3 to 6 months later, you will get a letter from Medicaid, because Social Security will report to Georgia that your child has qualified for Social Security income and supplemental security income, excuse me. And that automatically qualifies them for Medicaid. So you'll get a Medicaid letter that says your child qualifies. You then have to actually apply for the waiver. And in applying for the waiver, they're going to ask you to be very specific with regard to the types of services you need right now. For Catherine, what was really important was job coaching. You know, we as her parents have been able to handle all the other kinds of supports, but job coaching is hard to find as a private pay. And I just saw a question pop up. Yes, I mean the NOW and waiver and comp waiver programs. And those are handled by DBHDD with regard to application and moving forward.
Jennifer, this is Lori. I just want to take time to thank Jim for doing this for us.
Yes, absolutely.
You did a marvelous job, Jim. I think it's very important, you know, for our families to know that you're right there with us. You have a child just like we do. And we really appreciate everything that you've done for us and taking the time today out of your day to do this for us. We just can't thank you enough.
Well, Lori, I'm glad to do it. And, you know, being in the community, I understand, you know, it's one of those that there, but for the grace of God go I. If I hadn't been a lawyer, hadn't had the ability to do the things that I'm able to do for my daughter, I can't imagine trying to go through all of this complicated mess. And so to the extent I can provide any help or any guidance to anybody, I try to do so. And that's something I believe we all owe each other.
Yes, I agree. I would, you know, like to say that my child is 27. We do have guardianship and conservatorship with him, and we also have a special needs trust. So if anybody on here would, you know, like for us to do a future webinar like this on the special needs trust, let us know. It sounds like Jim is very open to doing that for us. And it is a complicated process, but we would be more than happy to do that.
Absolutely. And we really appreciate your time.
Glad to do it. And ladies and gentlemen, you can certainly ask additional questions to Jennifer or Lori, and to the extent they can't answer them, they have my contact information, and I'll be glad to field a couple of questions and try to help them as much as I can.
Okay.
Right.
So everybody who was a part of today, we appreciate so much you joining us, you interacting, and yes, we will have we will try to have all the resources available to you shortly, including this recording and Jim's contact information. So well, thank you so much.
You're quite welcome. Everybody have a great day.
Yes.
Thank you, everyone.
Thank you.